Good morning to one and all present here. The session will start shortly. Good morning to one and all present here. We are starting the session for today. I now request Dr. Rachel to give the welcome address.
Good morning, one and all present here. Pleasant morning wishes to you all for the third session on social status and legal rights of women. Gives me immense pleasure in inviting the resource person of the day, Ms. B.S. Ajeetha, Advocate, High Court, Madras. Ma'am, we have heard a lot on your vibrant speech and social activism. Thank you, ma'am, for accepting our invitation to ignite the young minds on sexual harassment of women at Workplace Prevention, Prohibition and Redressal Act 2013. We welcome you, ma'am, on behalf of the PG Department of Social Work, Self-Finance Stream, Madras School of Social Work. I welcome all the participants for joining the session. Your presence and your participation well heard energizes us, and we please stay tuned with us. Thank you, one and all.
Thank you, ma'am. I now ask Hamid Salvi to introduce the speaker of the day.
Thank you, Udaya. Today we have with us Advocate Ms. B.S. Ajeetha, who's running a law office founded by her father, late Advocate P.V. Bhaktavachalam, along with her husband, Advocate J. Saravanavel. She handles various cases, including children, women, labor, service matters, other civil and criminal appeals. She completed her BL in Dr. Ambedkar Law College and also did her ML in International and Constitutional Law from the University of Madras. Ma'am is a third party member in Sexual Harassment Committee in Anna University and SIT College for Women, and also the third party member in POSH Committee for L&T Companies, L&T Technology Services, and Kalakshetra Foundation. She has conducted various seminars and organized several meetings for marginalized section and actively participated in various other TV discussions. Ma'am, who is a member of National Alliance for Women's Organization, Regional Association of Women Studies, and the Legal Advisory for Chennai Managara Sirukadai Vyaparigal Sangam, and also for the State Federation of Association for Disabilities. Her various publications in Tamil include Rights of the Citizen at the Time of Arrest, To Know Various Rights and Methods to Ensure the Rights and Rights of Women, who has also translated The Protection of Women from Domestic Violence Act 2005 in Tamil language. It's a great honor to have you with us, ma'am. Over to you.
Good morning, one and all. Am I audible? Good morning.
Yes, ma'am, you're audible, ma'am.
Yes, thank you. I have a great pleasure in being amongst you in this webinar series, which is on legal status of women and legal rights. This is, I think, a fourth session, and I'm on sexual harassment of women at workplace, Prohibition, Prevention and Redressal Act. So this, when we go to this act, I really appreciate the organizers of this program for making an opportunity for the participants to learn, and also giving an opportunity for me to be with you. So when we understand the law, we are at least aware of it. When we are aware of a law, then we know what is our right we are entitled under the law. Once we know our entitlements, we will stand for it. Once we want to stand for it, then we understand the ground reality and also fight for us, and also not for the marginalized people. So the first step for bringing an equality or bringing a right into action is to be aware of what we are entitled to. So it is a learning, which is a process of making a change, and the change not only for us and for the women at large who are voiceless, who are marginalized, who can't speak up for their rights. So students of MSW, you are all more equipped, and you will be in various positions in sooner or later, and you will be handling many cases also. So the first step to realize our rights as a woman, and as a even if we are men, the quality men will always write for the equality of women. So the men also, they play a very strong role when they are sensitized and they are aware, and they are able to understand the various rights, and the concept behind the rights, how it comes to us and from where it emanates and all that. So today let's see the right of a woman to be treated equally in the workplaces. So when we call SHWP Act, it is Sexual Harassment of Women at Workplace Act. Actually, the Act says that it is for three aspects. One is for prohibition of sexual harassment. Second one is prevention of sexual harassment. Third is redressal. So it's all encompassed into one, and it is a central act to make you know that it is all over India, from Kashmir to Kanyakumari. This act is in vogue and it is practiced, and so it is implemented by the appropriate governments. The appropriate governments, or even if it is a central act, the organizations which is under the auspices of central government, or directly central government agencies or departments, or any other financed, partially financed central government or state government machinery, and all other private companies, whether they are incorporated under central act or they are a partnership firm whatsoever, and all other unorganized labor women who are citizen of India, are entitled for the benefits of Sexual Harassment of Women at Workplace Act. So it is both the act and rules are in place, and that is how we have the right to get the sanctions for non-implementation and get the right to get implemented various provisions of the act. Let us go and see the various aspects of it. Next slide, please, Uday. So any act or a right that where it comes from. So we need to know the acts are not in the vacuum or in the air. See, we have the Constitution of India, which has been there in place from 26th January 1950 when we become a republic. And the Constitution of India is the mother act, or from that is where we get all other acts emanated from. So without Constitution of India, we have no Indian system itself, the democracy or the entire civil society is based upon the adumbrated principles of Constitution of India. So Constitution is not a piece of legislation, just like any other act or statute. The Constitution is the one which gives right for enabling people to enjoy and enforce the rights which are very basic and fundamental. So in the Constitution of India, in the words of Ambedkar, if I have to say, he will say that without part 3 of the Constitution, that is fundamental rights of the citizens. So without part 3, that is fundamental rights in the Constitution part, I would call the Constitution as is not existing. So that is the one aspect. The part 3 alone speaks of the right of every citizen of India, how they will have various fundamental rights. That is right to equality, right not to be discriminated, right to life, right against exploitation, right to do any profession, right to freedom, freedom of speech, freedom of expression, freedom of assembly, freedom of doing any profession. So all these rights are fundamental rights. So the right of a woman to not to be sexually harassed in the workplace is very clearly comes from our Constitution. The preamble itself says equality of status and opportunity must be secured for all its citizens. Equality of every person under the law is guaranteed by Article 14 of the Constitution. And a safe place is therefore a women's legal right. Indeed, the constitutional doctrine of equality and personal liberty is contained in Article 14, 15, and Article 21 of Indian Constitution. Article 21 is right to life. Right to life means right to live with dignity. And if we have to live with dignity, we need to have a gender just workplace which prohibits, which protects us, which prevents sexual harassment at workplace. So this is the basic source from where we get our right against sexual harassment. And next, we get the right also from the international covenants. See, not only the local laws or the municipal laws, our constitution alone gives a source for our laws, but also the international covenants. So one covenant which we need to know, you would know that CEDA, the Convention on the Elimination of All Forms of Discrimination Against Women, which is the Bill of Rights of Women. They have spoken about so many rights in 16 articles in CEDA, which also gives gives a source of are getting a right to equality at workplace, right to equality and right to life itself. Because if a person is not allowed to do their profession freely and with fairness, and it is not a correct environment, then there is a discrimination, then there is no equality at all. So to have a rightful, equal, and non-discriminatory work environment, the women should be free from sexual harassment, if at all it happens in workspace. So this is not a mere right of just having a right against sexual harassment, but it is the basic fundamental right itself. Right to right to live is to right to live with dignity. Right to live with dignity is definitely free from sexual harassment any place, especially in workplace also. Let's go to next slide. So when we think of any law in this country, you would have listened to some other acts also for the past 2-3 days. So whichever law that is brought in this country, that is because this society, this civil society is bereft of that particular right. And it is writ large on the face of the entire society that that particular right is being infringed, or that particular right of a citizen is not being respected, or it is not taken care of by the welfare state. So whichever society which is in need of particular act is, without going to prove it, we can understand that that particular right is not there in the society. So when we are bringing up an act of domestic violence in a country, it is very clear and obvious that there is domestic violence is existing in the country. If we are bringing up some epidemics act, then we have to understand that epidemics are prevalent in that society. So when a society or when a country, when a polity is bringing up an act against sexual harassment, then it is very clear, and it means and includes stating that a statement of fact that that particular society has sexual harassment prevailing everywhere. So why the sexual harassment is there in first place? Then we need to understand the role of patriarchy. So the sexual harassment constitutes a gross violation of women's right to equality and dignity. It has its roots in patriarchy and its attendant perception that men are superior to women and that some forms of violence against women are acceptable. One of these is workplace sexual harassment, which views various forms of such harassment as harmless and trivial. And many times we can see that flirtations, which is also an intrusive flirtation, which is an opposed flirtation, is also considered to be a very harmless, trivial, and jovial or a casual act of a man, which women have to accept or are given a go by. So this is the role of patriarchy, because this kind of understanding is also there for women also. The women also feel that definitely, if we are fine, if we are dressing up well, if we are going to the public place, we will be definitely given some kind of harassment, including sexual harassment, because we are female sex, because we are women. So this kind of a mindset is also emanating from patriarchy. Next. So many women, they don't complain about the sexual harassment because they're afraid that there will be reprisal from the harasser, and losing a person's livelihood, and being stigmatized, and losing professional standing and reputation also. So many cases, the women are taught to keep silent. Women are taught not to open up. They always say that they are given several examples to tell them or make them understand that the reprisal will be more worse than the problem itself. So even if you undergo the sexual harassment, at least you protect your job. At least you don't get the wrath of your senior officials. At least you safeguard your livelihood. So these are all the things. And the loss of reputation. Everybody will start looking at you in a different manner, or sometimes there will be a name calling. And there is a very pathetic situation or a mindset or a fact reality that is prevailing in our society is to make the victim responsible for the crime or the harassment itself. So when it comes to several other serious heinous crimes, the victim is not made the person who is responsible for the crime. But when it comes to the crime against women, when it comes to the sexual harassment at workplace or in any other place, in public also, then the society has an idea of putting the blame squarely on the women, saying that only because this girl is inviting, the problem has happened. If she is not being very comfortably welcoming it, why would it happen for her? Why not to some other women? So these kinds of hollow arguments, which is another form of victimizing the victim herself. So this is there for several years continuously, and all the time we are able to see, even for a small child who's 14 or 15 or 16 years old, when some other boy or a girl in the roadside, she is being teased or she is being sexually harassed by just a verbal tease or any other unwelcome gestures and all that. The family members, at least not now, 20, 30 years back, they used to say, if you don't look at that boy's face, how would you know that he has winked at you? If you don't look at his, that side at all, how will you know that they are singing a song towards you? So all these things are very clearly so showing that victimizing the victim is a regular phenomenon in India and in several other countries also. So the women don't complain of sexual harassment due to the fear of stigma and all other aspects that we spoke of. Next. The change is possible by implementing the SSWP Act. By saying this, we say that we have to be the change that we want to be. So when we expect a change, what is from the present situation, definitely we need to work for it. So just merely talking about no for a sexual harassment, opposing a sexual harassment, or giving back or retorting back to us for a sexual harassment alone doesn't work. If there is an act in place and the act says that what are all do's and don'ts, and if the act is giving sanction against the persons who are violating the act and provisions of it, only then the change will occur. Because when a particular aspect or a behavior is reinforced by patriarchal system and the culture and the religious ideas and value system that each one has imbibed from their birth, will not go unless there is a act that is in place, and also act calls a particular behavior as a violation of the act, and that particular behavior which has been prevented or prohibited by the act will be given dealt with very seriously, and there would be sanctions for it. So if there is no act, calling an act is illegal, calling an act as a crime, then nothing would change. So there has to be an effective act and there has to be an effective implementation of the act. So that is what is also required in the sexual harassment issue. And also we should know that an effective implementation of the act will contribute to the realization of their right to gender equality, life and liberty, equality in working conditions everywhere. The sense of security at the workplace will improve women's participation in work, resulting in their economic empowerment and an inclusive growth. Next. Can we go for next slide, Udaya, please? Yeah. So it is not the will and pleasure of any employer to have this act or not to have this act. It is a mandate. All workplaces in India are mandated by law to provide a safe and secure working environment free from sexual harassment for all women. This is the mandate of the India at present regarding sexual harassment. And we should know that many countries in the world, we are about 195 countries, including Taiwan, it's 196. Many countries doesn't have this kind of act. So we are not like all the countries that it has act in place. We need to understand that it is mandated now in India from 2013 onwards only. Let's go. When there is an act, there will be some history behind it, and we should understand what is Banwari Devi's case. See, there was a woman by name Banwari Devi. She was in Rajasthan, and this woman is a Potter community woman, marginalized, poor, and daily wage laborer. And she was in a watchdog committee for prevention of child marriage. The act is having a scheme to have a village level, taluk level, and district level committees, state level and national level for prevention of child marriages. And also we have some similar committees for prevention of dowry also. So as per the scheme of the act itself, which the act of prohibition of child marriages, even in Rajasthan, there are committees, and there is last level of committee, which is a village level committee, in which Banwari Devi is made as a member. It is actually a namesake and it's a routine kind of a membership which constitutes the committee. For that sake, the Banwari Devi or several other women could have been included or taken into the committee. But Banwari Devi, true to her position of a member of the committee, went and complained that there was a marriage that was scheduled and likely to take place for a child who is 1 year old. It is not too old or an adolescent child. You should understand it was 1 year old child. The marriage was scheduled. So she rightly, as per her mandated duty, went and complained to the committee and the committee to the higher level committee and all that. But immediately she got a reprisal from the community, an upper caste community who arranged the marriage, and they have very strongly came against her. And Banwari Devi was, as a retaliation for the complaint or the fact that was given by her to the committee, she was gang raped in her working place, that is in the sugarcane fields. Banwari Devi was very badly gang raped, and the violence was so bad, and her husband was beaten up, and he was dripping blood all over. And the couple would go to the police station and complain about the very heinous violence and crime that is committed upon her without knowing what has happened. But soon she was able to understand that that was the retaliation for the legal duty for which she was mandated to do. That was the retaliation, and she suffered. And later there was a case, and the court has allowed the accused person to go free at the district level court, saying that these kind of rich class men would not have gone and done all these things, and there is no other witness and all that, and they were all acquitted. And the matter went for High Court of Rajasthan for appeal in the criminal trial, and they were punished. But later this case was taken up as a very serious one case example for all the women, all the working women at in several workplaces all over India, that they are not having safe workplace at all. So there were several women groups. Let's go to the next slide. So several women groups, including Vishaka, they have filed a case in Supreme Court of India, which is very popularly came to be known as Vishaka versus State of Rajasthan in 1997. That case has very clearly laid down the guidelines, and first time in the history of India put down the definition of what is sexual harassment, and it is based its definition and other things basing on our fundamental rights, and also the aspects that has been taken from the UN Convention of CEDAW, and they passed the judgment. That is a landmark judgment. The Vishaka case has given India a new leaf turn for the women, for entitlement of the right not to be sexually harassed at workplace. That is an expansion of right to equality. That is an expansion of right to life. That is an expansion of right to live with dignity. And that's an expansion and clear explanation of right of non-discrimination at working place. Let's go. So the Vishaka case also had some other basic aspects, what I've just told you now. It included a definition of sexual harassment till 1997, for 50 years after independence, for 50 years of independence, we never had any definition in entire law books for sexual harassment. That was 1997 was the first time India had at least a definition of what is sexual harassment. And the Vishaka judgment made another very leap forward conclusion, that shifting accountability from individuals to institutions. So we all know, as we spoke earlier, that victimization of victim itself is the norm in all crimes, especially sexual harassment crimes against women. So this judgment has shifted the accountability from individuals or victims or whomsoever to the institutions or people who are responsible for it. And this judgment has also came out with a clear ideas of prioritizing the prevention. It is better always than acting after incident has occurred or taken place, or punishing the persons who have violated. So prevention is much better, because a woman is protected and saved from becoming a victim or a sufferer. And provision of an innovative redressal mechanism has been given in this judgment. So the next slide we can go. So the SHWP Act itself has come from the Vishaka judgment, and Vishaka judgment has been more modified, clearly construed certain other things, and the mechanism for redressal is put in place in various provisions of the Act. So now let us see what is sexual harassment at workplace. This is the definition itself. Sexual harassment has 5 aspects. So it doesn't mean that all 5 aspects put together makes an act a sexual harassment, but any one component of this definition is there, then that means it's a sexual harassment. The first one is physical contact or advances. Second one is a demand or request for sexual favors. Third one is making sexually colored remarks. The fourth one is showing pornography. Fifth one is any other unwelcome physical, verbal, or non-verbal conduct of a sexual nature. So all 5 components put together is a sexual harassment. And this aspect has to be there in any form or in one form or in implied form at a workplace. So let us go about all other aspects, like what is workplace, who is the aggrieved women, and all that. Next slide, please. So who's the aggrieved women? The next question is. So any woman who's working is an aggrieved woman. Then the question will come whether a maid or a domestic worker or a cook at a home, an individual's home is a aggrieved woman. Yes, she is. So it is not only a full-time working place. It need not be a permanent employment. It need not be that they should be a government employee, but a woman working in any place, in any level, like permanent or temporary or a contractual labor or a person who is visiting a workplace or a student, all these people are aggrieved women. So what is working place again? So working environment is not only a typical working environment which we all imagine and to our levels and about our understanding. So a domestic worker is a working woman, a regular temporary, an ad hoc or a daily wage worker is also an working woman. And whether a person is working for remuneration or a voluntary basis or otherwise is also working, employed directly or through an agent is a working woman. Contract worker, probationer, trainee, apprentice, called by any other such name, would also come under aggrieved women under this act. So many employers normally think that having a permanent employee is a problem. He has to be answerable or accountable under many statutes, and he has to have books and all that. So people, small industries or bigger industries or even the corporates, now having a kind of a new work environment by having many people, but not as a permanent employee, as in the voluntary basis kind of things. But this act encompasses all kinds of women who are working. So this means apart from women who are working in their own respective homes, all other women who go out or sit within the home and work for any manner to make their services rendered for remuneration or voluntary, then they become a working woman. So this is an all-encompassing definition about aggrieved women. And before I speak about workplace, I'll have to just tell you a very important thing. This act is a gender-specific act. See, the act, every act in this country, every statute in this country are applicable for citizens of India. So citizens means all men, women, third gender, everyone comes under that. So this act, when I'm saying gender specific act, that means the relief that has to be claimed should be by the women, only women, because this is gender specific. So when we talk about gender neutral act, that can be used or implemented by the aggrieved women or also aggrieved men. But this act is a gender specific act which says that sexual harassment is discriminatory and it is violation only if it is done on a woman, not upon a man. We will come to that later on in your question answer session more. So what is workplace? As I told you earlier, it is government organizations, NGOs, house, nursing homes, corporations, companies, farms, educational institutions, sports facilities, hospitals, any service providers, cooperative societies, your college, university, and my working office, like whatsoever. Wherever there is a work that's happening, that is the workplace. Let's go to next slide, please. Next slide, please, Vidya. So recognition is the first step to prevent the sexual harassment. That is most essential aspect of it. The workplace sexual harassment is behavior that is unwelcome, sexual in nature, or subjective experience. Impact, not intent, is what matters, often occurs in the matrix of power. So whichever words which you are able to see in the screen that has been in the capitals are the most important aspect of this sexual harassment concept itself. It has to be sexual in nature. It should be unwelcome. For example, if two people are there, colleagues, and they're working, and one comments over the other sexual in nature, and the woman who is subject in that conversation or an act or in that exchange, if she's welcoming that act, then it doesn't become a sexual harassment. So sexual harassment per se has 3-4 aspects and components, which is: one is unwelcome, number two, it has to be sexual, number three, it has to be a subjective it is a subjective experience, four is an impact on the victim or agreed women, and fifth one is the power. So the power matrix, we will understand it little later also in the next part of the in the later part of the discussion. So let's go to the next one. So what is welcome, what is unwelcome? Now, man can say always that I'm very casual, I'm a jovial person, I'm very funny man. So I would like to comment like that. I would like to tap on her shoulders or a back or whatsoever it is. So if a person can claim himself to be very bubbly, outgoing, and an extrovert and all that, cannot get into a defense by saying it was welcome according to him, because welcome or unwelcome is by the impact of the agreed women. So what it feels like, welcome or unwelcome, for us to just understand in few examples. See, unwelcome feels bad and welcome, it feels good. Unwelcome is one-sided and it is reciprocal. The other way it's welcome. It feels powerless. And welcome is one, it is in control. The woman is in control of what is transpiring around her and with the relationship with the person who is involved in the act. So it is a power-based, and welcome is equality-based. It is unwanted, and if it is welcome, it is wanted. If it's unwelcome, it is illegal. If it's welcome, it is legal. So it is invasive and it is open, and it is demeaning and it's appreciative. The unwelcome acts normally causes anger and sadness, but welcome act always gives us happiness. And unwelcome causes negative self-esteem, but a welcome act will always cause a positive self-esteem. See, these are all the things. Many times the women are left at a confusion to know whether he committed a wrong or not, whether he committed a mistake or not, whether it was inappropriate or not. So for that, the scale of test is only one: whether she feels welcome or unwelcome, whether a feeling is good and if she is feeling appreciative or if she is feeling very down. So that is the reason why I told you, and we saw in the earlier slide, that the unwelcome is the word which is most crucial in deciding on the sexual harassment and the act, whether it is an harassment or not. Let's go to the next slide, please. There was lots of issues surrounding the sexual harassment and the complaints and the inquiries and the redressal mechanisms, because many times men readily came with a defense saying that I did not mean, I did not intend to do that, I was very casual, I respect women, I only pray to women goddesses. The goddesses of my family are women, and my mother is the first god for me, goddess for me. All these things they come. So the Supreme Court and High Courts have given several judgments after Vishaka judgment in 1997 that when they were dealing with the sexual harassment cases in 2010, Delhi High Court in Dr. Punita case, this case is Dr. Punita versus Union of India. This case, they very clearly said a complete understanding of the complainant's view is required in dealing with this matter, and an analysis of different perspectives of men and women is also required. The conduct that many men consider unobjectionable may offend many women. Men tend to view some forms of sexual harassment as harmless social interactions to which only overly sensitive women would object. The characteristically male view depicts a sexual harassment as a comparatively harmless amusement. So this is what has been told by Delhi High Court. This is very, very clear expression of the mindset of the violators or aggressors or the men who indulges in the sexual harassment complaints. So it is very clear and very obvious that it has to be viewed in the perspective of the women, not of the men who is committing the offense. It is a subjective experience because she is the person who undergoes that. This is not quantifiable from outside. It's a murder, it's a grievous hurt, it's an injury, or it's a defamation, or several other offenses or the crimes that has been listed in the Indian Penal Code or any other criminal statutes. It can be seen, understood, or quantified. But the sexual harassment is a very subjective experience, and that is the women that undergoes, and that is the very reason why it was not addressed for several decades, for several centuries, till like in 2013, even in India itself, it was not defined, it was not taken up as a violation against women at all. So we have to understand the very, very important aspect and concept of explaining sexual harassment is that it is a subjective experience. This has been reiterated by the High Court of Delhi also in 2010 in Dr. Punita versus Union of India case. Next slide, please. And we have to understand two aspects. That is, sexual harassment very typically happens in two sets of environment or two sets of two forms are there. In two aspects, we can understand it better. And if that particular matrix is prevailing, then the sexual harassment can easily be inferred and understood and should be concluded. So the first one is quid pro quo. It literally, very simply means that this for that. The quid pro quo can be implied or explicit promise of preferential or detrimental treatment in employment, implied or expressed threat about a present or future employment status. It is typically comes like, if you're accepting my advances or adjusting with me, you will be awarded with a promotion. Or at the same time, sometimes they can say that if you're not listening to me, if you're not acting to my fancies or whims, then you will not be here in this place, and you can be transferred, you can be dismissed, you can be terminated. And it is, we can understand it in a simple manner of the daily wage construction women laborer to the masonry supervising person. So when a lower grade, the last rung women construction labor is not adjusting or accepting or accommodating the advances of ugly, sexually colored or sexual natured responses from the top person, that is the mason, or from the person who employs her, then she will not be having work for the next day. So it directly calls for losing her livelihood. It directly impacts her right to life and her profession, and to earn money and to live a life with dignity by earning few rupees for making her family be in a better economic status. So when this kind of situation is there and a woman is complaining, then it's a very clear case. The form of quid pro quo is there. Either it can be preferential treatment or detrimental treatment that can be threatened with. So this is quid pro quo. This can always, we can see this in a given case or a complaint or a given environment when a woman is complaining about a particular person. Or sometimes it can be a hostile work environment situation. This is creating an hostile, intimidating, or an offensive work environment and a humiliating treatment likely to affect her health and safety. For us to understand this aspect, I can just give a very simple example. A woman who was expected to do some sexual favors for a person above her in a higher position. When she denied it, when she said clear no, there was a reprisal from him saying that she will be shouted at in front of everyone. She will be name called as a lazy person or always a lagging behind person and a useless one in front of others. And the reprimands will be disproportionate for the triviality of the mistakes that she commits. And many times that particular person will be asked to do more work at the verge of closing the office times, and she can be dumped with lots of files at 4:30 or 5 o'clock, just she starts leaving home. And these kind of several instances we can understand about giving an hostile work environment for the person who is aggrieved. And an aggressor will do all these things, but it can be dubbed as being a strict employer, being a very tough master, being a person who is very workaholic and gets work done from all his subordinates. So he can actually show it in a different manner only by creating an hostile work environment. So when there is sexual harassment complaint coupled with this kind of behavior, we have to understand it's another form of sexual harassment, which is similar to quid pro quo or in a different form of a sexual harassment. Next slide. So how to redress all these things in a company, in a work environment, in an office, in a university, in a college? We have lots of such situations coming up every other day, and especially we know and we understand, as you're all PG students, you would have heard stories after stories about the research scholars they undergo with the guide or the people under whom they have to get their proposals and their theses approved, things like that. So the complaints committee is a mechanism that has been created in all over the places. And when Udaya, when Tamarasi spoke, I think she also said, I'm also a third party member in Vienna University and Madras University. That means very clearly that even university campuses are considering the women students as that of an aggrieved woman under this act, though they are not typically an employed person or a worker anywhere in the university. So the campus itself is a workplace. Entire precincts of campus is a workplace. So there is a complaints committee even in all educational institutions. And so it provides for, the act provides for two types of complaints committee. One is that ICC. Earlier we used to call internal complaints committee. Now it is amended to be called as IC, internal committee. And second one is local complaints committee, that is LCC. Wherever all the complaints committee there should be complaints committee wherever there are more than 10 employees in a given private or a public or whatsoever a sector or an industry or whatsoever. ICC should be there. And less than 10 people, then they can attach themselves to LCC. LCC basically deals and covers the women who are in unorganized labor sector. A woman, if for an example, a roadside vendor, a woman who's having a bunk shop, and a person who's going for a work in a individual house as a maid or a cook or a top worker, those women, if they're harassed, and the employer will not definitely come to her rescue. So she has to go to LCC. The LCCs are there in every district. In each district, there should be an LCC under the chairmanship of a committee, which will have a leader of a person, a woman, who should be a prominent and social worker who is known in the locality or known to the officials also, to continue to work as a person to empower women and who understands and work for women's rights. So the LCC is basically, it is in the unorganized labor sector. So that is available in every district level, and there should be a third party member. Let us now go to the composition of the committee. So the committee should have a chairperson who should be a woman, a senior most person or a senior level person. And if there is no senior women available in that particular office or that unit, then it has to be from other office or unit department under which this workplace is covered, of the same employer. And there should be minimum of 2 members from amongst the employees committed to the cause of women. We have to underline this: committed to the cause of women, having legal knowledge, experience in social work. There will be some women who will be very patriarchal, who will be very uh, chauvinistic, and say that the women should not have any rights and women should be subservient for men, and women should be like women who lived before 100 years, they should not study. There are women we are also able to see rarely, or sometimes many times also. It is to our disgusting plight. We see many women like this also. So there shall not be any member who doesn't have a commitment or understanding for the cause of women and who doesn't have any experience in social work. And third is most important, is that there should be a third party member, an external member like me or like Adi Lakshmi, who was there with you 2 days back or 1 day back. They should be from amongst NGO and associations who are committed to the cause of women. So that they should be also most preferably a woman, and also they should have knowledge either in civil or criminal or labor or service law. So this is the structure or composition of internal committee. The same criteria apply for LCC also. And you know that there should be more than 50% of the committee should be comprised of women. So if we say more than 50%, if it's an odd number, it's easier. At least more than half will be women. And if it's even number, then again it has to be seen to that more women are there in the committee, because this is statutory requirement. It is not the will and pleasure of the employer who is establishing such committees. So next one is sexual harassment at workplace. There should be a policy in every workplace. So we normally call it a POSH policy. So actually we call it POSH because it's a policy on sexual harassment. So every employer will have a POSH. So that is their organization. They will set up a set of rules and regulations, and the policy will be in place, which is normally and many times called as zero tolerance for sexual harassment policy. So they don't tolerate any form, in any manner, implied or direct. And so that particular employment or organization or association or that institution will declare that they have a policy that they have a zero tolerance towards it. So in tune with the provisions of this SHWP Act, that particular organization will frame its policy and form committee, and that will be put in a conspicuous place of in the office and the notice boards, even in all notice boards of university campuses and college campuses, educational institution campuses. They should have the names of the members of the committee and the contact details also. This is also a statutory requirement to make the students and the employees one and all be aware about the existence of such committee. So they should be accessible also. So every organization should have a policy. So who can complain? Then this is too a small letters because it's too many. See, persons are women, agreed women who are physically incapacitated, who are mentally incapacitated. If agreed woman is dead, and in case complainant is unable to file a complaint for any other reason, that is she was being hospitalized or she's been under arrest or whatsoever, then many times the complainant's relative or their friends or co-worker an officer of National Commission for Women or a State Commission for Women can complain on behalf of the complainant. So only if the complainant is incapacitated, the other people can always come in and they can complain against her. But it cannot be a proxy complaint, or it cannot be a complaint by a lawyer or a solicitor or a representative. So these situations of physical incapacity, mental incapacity, in case of death, in otherwise they are incapacitated, or all are accepted. In all these cases, it is accepted that complainant can give complaints through other persons, but not on a regular basis, that she can always engage a person for her convenience or whims and fancy. Next slide, please. So what should typically a complaint should contain? So the complaint cannot be vague or very generic, or it cannot be generalized statements without mentioning anything, names, or putting anybody into accusing anyone but in specific. It can't be general. A girl cannot say that this campus is very bad, this college is not respecting women's rights, this campus, the teachers are very insensitive and they are not good at all, they are making comments on women's body and their other things, so it is very bad, and you are all violating the SSWP Act. There cannot be a complaint like this. So typically a complaint should have a date, this description of incident or incidents, the date or dates of the happening, the timing, the respondent's name, parties, working relationship, that is who were all there, and what is the relationship between the respondent and the complainant. Definitely these 4 or 5 aspects should be there in a complaint. Otherwise the complaint will not be holding good at the time of inquiry, or the girl tend to lose, or even the committee will at the first place, before informal discussion, they will say that this complaint is not acceptable complaint because it is not very specifically mentioning. We can't say, it is just like telling a police officer telling a person that I was beaten, I was injured, I had a blood injury and all that. We should say where, when, what, how, by whom. All this question should be answered in a complaint. That is what a proper complaint is. Next. So when we have spoken for about an hour or so about the aggrieved women and their rights, and how they can complain, where, who's an aggrieved women, what is the concept behind it, all these things we have seen. Now there's a time to see the rights of the respondent also. Very in this statute and by the rules, we don't call this person as an accused. It isn't in a work environment. It is a semi-private, semi-public space. All workspaces are semi-private, semi-public space. So we call, the act calls, the statute calls them as respondent. So it's an answering respondent. So the respondent has some rights because the entire inquiry, entire punishment will be awarded with the principles of natural justice given to all the parties involved in the complaint and in the entire mechanism. So the respondent will have a right to self-defense if he is innocent or otherwise before he is being awarded a punishment. So the right of a respondent includes a patient hearing to present his case in a non-biased manner. The committee should be like this. And a copy of the statement along with all evidences and a list of witnesses submitted by the complainant should be given to the respondent. Respondent cannot be kept under dark and say, no, you answer. We come to know everything. We know about you. Come on, say what has happened on that day. This cannot be the way the complaint can be proceeded with. The respondent should have the copy of the complaint itself along with the witnesses. And next one is, the entire proceedings are to be kept as in confidence. It is in camera. The proceedings are in camera proceedings. That is to say that it is completely confidential. No information about the complaint or the proceedings of the complaints committee can go out. If it is done by any member, the member loses their capacity to continue as a member in the committee immediately, and they can even be taken action against. So when even a member has got this rule to follow and be implemented, definitely the committee and the employer and the victim victim can definitely talk about this to her colleague workers or her friends and other people who are going to be the parties to the thing. But the respondent cannot say or tom about the proceedings at all. And also his identity will be kept confidential, and he has to keep the aggrieved women's identity confidential. Some men can go on a rage and tell all wrong things about the women to just tarnish a name, which can start off as soon as she complains, so that she will be intimidated, she will be threatened and all that. So definitely the confidentiality is one of the essential aspect of the entire complaint mechanism from the inception of the complaint. So the respondent is also benefited by that, and right to appeal in case if he is not satisfied with the recommendations or findings of the complaints committee is there for the respondent. So as the aggrieved women also has a right to appeal. And we have to understand the timeline, because many laws in India, several laws are very ineffective only because there is no time limit, and it is the justice comes very delayedly. And we all know we have a very popular and proverbial saying of justice delayed is justice denied. So there is a timeline fixed in this act. It is a statutory provision to be followed. The committees have a duty towards going by any complaint as per the time schedules given in the act. The submission of complaint by an aggrieved woman should be done within 3 months of the incident, or if it is a series of incidents, then it is a last incident. So she can't delay it beyond 90 days, but she can give a special reason if she is incapable of giving a written complaint prior to completion of 3 months time. Notice to respondent should be given by the committee within 7 days of receiving a complaint, and completion of inquiry should be done within 90 days from the date of receipt of the complaint, and submission of report by either LCC or ICC should be given to the employer or a district officer respectively within 10 days of completion of inquiry. So we are able to see here on 100 days time is complete from the inception of complaint till the award is the final decision is report is given to them, decision is taken to them. And implementation of recommendations cannot be put in cold storage, and it has to be done within 60 days by the employer. See, a committee can typically give findings and recommendations. The finding can be that the complaint of sexual harassment is true and she has been harassed, and this has been physical advances, this could have been a unwelcome gesture has been committed, whatsoever can be the finding, and it should be coupled with a recommendation. Because at the advent of this act, all the service rules in the length and breadth of a country has been amended to include punishment for commission of sexual harassment. Even in the Factories Act also, the standing orders have been duly amended to include the punishment for it. So the sexual harassment punishment can be even up to termination or excuse me, dismissal from service. So this has to be done within 60 days, and the aggrieved person, either aggrieved women or the respondent, can appeal against the recommendation within 90 days of the recommendation. Next slide, please. So from all these things, from the act and statute, a safe workplace is every woman's right. There is no difference whatsoever. Thank you.
Thank you so much, ma'am. Now we will go forward with the question answer session.
Yeah.
So the first question is from Manjula. Her question is, what are the rights for a social worker in the locality, particularly to the panchayat?
Okay. See, if she's a social worker in the locality, and if she is not been taken into the committee, that is LCC of her area, she can always go talk to the women and encourage her to lodge a complaint when there was an act of sexual harassment has been committed against her, and she can stand with her to take this forward and put this complaint in proceedings started in the LCC. And definitely the awareness to the women and sensitizing the men in the locality is the most important expectation of this act, and that alone will bring down the number of sexual harassments that is being committed against women.
Ma'am, the next question is from Dr. Pratima Mahidas. The question is, after the Me Too wave, recruitment in private sectors for women has reduced drastically. Are there any rules for a private sector where recruitment percentage of male and female employees?
That's a big, larger question. There is no reservation like 33% of women should be employed by even private sectors also. Since independence, we have been in welfare state, and from 2000s onwards, we are seeing that the India is going for privatization, liberalization, and globalization, which is bringing down the number of uh, jobs in very dwindling, and also they don't subscribe to the constitutional mandates because the laws of India are giving right for private establishment to not to implement the rights of reservation. So the reservation not only on the lights or on the lines of economic and social discrimination or backwardness. Also, women are considered as marginalized people, and that is the reason why we had 73rd Amendment in the Constitution, so that all local bodies, the panchayats and Panchayati Raj system itself, as is very inclusive to have 33% of women. So this is a big dream, and it's a longer goal that we need to achieve with respect to private sectors. The private sectors are now in the spree of reducing their number of employees because of increasing the working hours. Especially after Corona, we are able to see the long fought rights of 8 hours or 9 to 10 hours, including the travel time, is lost, and the set of laws which we are giving and it's entitling the labor for some basic rights are being vanished and being taken away by the state and the government in the name of supporting the industries and industrial sector. It's detrimental to the labor, and so it's a larger fight, and we need to take up this slogan for having 33% or whatsoever percent for women should be reserved even in the private sectors. This is a goal that definitely needs to be achieved, and we have to desire for that. We are not having any such laws now.
Ma'am, so the next question is from Pratibha as well. She is asking if the beating of the accused by the family members of the aggrieved women punishable by law.
Yes, of course, but not under the Sexual Harassment of Women at Workplace Act. It is a domestic violence, and the family members are beating her. Definitely, it's a physical abuse, and she can complain to the protection officer who is placed in Tamil Nadu in every district headquarters under the Department of Social Work and Social Defense. There's a protection officer who is a nodal officer to take the petition to the court. So even she can complain it to the police as well. So aggrieved women getting beaten up by the family members is clearly a simple per se crime against the women by her own family members, but it doesn't come covered under this act.
Ma'am, I guess the question was the accused being beaten by the family members of the aggrieved women. So
Okay.
is that punishable?
Yeah. Yes, accused is definitely, because the aggrieved women's family member have no right to beat him. They can't take law into their hands. So for beating up the accused person by the members of aggrieved women, he can go give a complaint to the police or police station, and it is punishable by IPC, Indian Penal Code. I'm sorry, I mistook it as a aggrieved women being beaten up their family members for having given a complaint, things like that. Okay.
Okay, ma'am, sorry. The next question is from the YouTube chat box. Nanda has a question. Sexual harassment committee will also be suspended if government going to suspend the labor laws for 3 years due to lockdown in India. Can you please comment on that?
Yeah, definitely. The lockdown or the situations that is changing faster after the corona, they cannot take away the right of the complaints committee, nor they can take away the implementation of the SHWP Act itself. So wherever there is an employment, there is an institution, all those places, a mandatory committee should be there as a redressal mechanism of this act, and that cannot be taken away by any government.
Thank you, ma'am. The next question is from Vidya Ramkumar. Her question is, what if there are no witnesses to support the victim?
Yes, I told you that many cases of domestic violence, many cases of sexual harassment, many cases of uh, sexual violence against children and rape kind of cases, they don't have eyewitnesses at all. So the woman who is uh, making a complaint again about an incident against a particular person can be proved from her statement itself. So even a rape law has a very clear law that has been established now in recent past, that the confession statement, not confession, it's the deposition or the statement of the prosecutrix, that is an affected girl or a child or a woman alone, is enough to convict a person even in criminal law. So the preponderance of probability is the rule of concluding sexual harassment, whether it has taken place or not. The complaint of sexual harassment need not be proved beyond reasonable doubt. That is not the principle behind the inquiry or the proceedings of sexual harassment. The principle in dealing with this sexual harassment is the proof in the manner of preponderance of probability. So that principle has to be applied. So definitely she can establish her case by making her statement and explaining the attendant circumstances and the relationship between the aggrieved woman and the respondent, and if there is a quid pro quo situation prevailed earlier, or there was creating an hostile environment where there can be a secondary witnesses to that, people who could have seen an hostile environment being created for her in the past, and all these things can be proved. So it is not required to prove the case beyond reasonable doubt. So an aggrieved woman need not be afraid of, scared of, that she can't prove, etc. So the level of the principle of proving the case is much lesser than the criminal complaint proof.
Thank you, ma'am. The next question is from Oliver. His question is, does work from home or working online comes under workplace? And does traveling outside workplace for office-related matters or travel taken to and fro from the office includes as workplace?
Exactly, it's a very good question. Yes, it is. A person who is working online from home and he gets any pop-up messages or online harassments, he or she gets a message saying that at the time when she's logged into the office computer, in the same line some other person can come in a private talk and say that, now accept, now tell me, I'm proposing you. If all these things are happening, then again the person is underwent a sexual harassment at workplace, because she is logged into the system computer or an iPad whatsoever, only the duty or an employment mandates for it. In that situation, if she is harassed in any manner, either electronically or by any other media, definitely the definition of workplace will come. And second aspect of it, the travel on board a bus or a vehicle where a woman is traveling along with another person in a private car also for a call of duty, then that car and on board the vehicle becomes a workplace. Per se, it is a workplace. So there's no doubt whatsoever. And the workplace can be extended to all other public places where a woman get harassed by a co-employer in that public place becomes a workplace.
Thank you, ma'am. The next question is from Mr. Arun Kumar. So what about the punishment for sexual harassment?
Punishment is in the workplace, it is dismissal or transfer or whatsoever. See, the punishment, there are two aspects. It's actually a nice thing that can throw light on the other aspect of it. See, sexual harassment is a violation of statute of SHWP Act in the workplace. So it will give rise to a civil consequence of losing his job and employment also. At the same time, if the aggrieved woman chooses to give a criminal complaint, she can give a complaint under section 354 capital A in any police station or in the locality in which she has been sexually harassed by that particular person. For example, in the office place, or if it is online sexual harassment from the home jurisdiction, that police station she can go give a complaint. That IPC has a provision for punishing the accused person if the offense is proved, for 3 years imprisonment.
Thank you, ma'am. The next question is from Minu Mary Dilip. The question is, can you give the age group for women who will be protected by this act?
Kindly come again.
Can you give the age group for women who will be protected by this act?
No, I don't get the question.
She's asking, what is the age group of women?
Oh, age group. Yes. Yeah, the age alone I didn't hear. See, the women who can be employed or who are in the universities are definitely they are 18 plus, or sometimes the girls who are yet to complete 18 years can get into university or educational institutions before they are 18, because they complete their +2 in the age of 17, and they could be few months away from completion of 18 years. So any student in that particular university or college will be covered under this act only because she has become a student already. And in all other employment, mostly they are 18 plus alone are eligible for employment, and there cannot be any child labor existing in our country as per law. So 18 plus is the women who can be covered under this act. For the children who are less than 18 are called children, be it a female child or a male child. Those children are covered under POCSO Act, Protection of Children from Sexual Offences Act. So wherever there is an harassment or a penetrative, non-penetrative sexual violences, harassments, then POCSO will cover them. So women typically 18 plus, the adult women are covered under this act. In rare cases, less than 18, if they are the first year students of an university, and if she wants to complain, definitely it can be there. It can also be coupled with a POCSO complaint for that particular girl.
Thank you, ma'am. The next question is from Monojit Ghari. His question is, what are the roles to be played by a professional social worker in dissemination of information and awareness generation?
Yes. See, a professional social worker, I understand in two terms. One is that he can be a kind of an HR in a big institution or a company or an employment. Or a professional social worker will be having an NGO for working with the people. Or without having an NGO, he can be an individual in the community. And so in any aspect, in all these roles, he can definitely make the right of the women aware and the duties of every man to act responsibly without violating the provisions of this act can be disseminated. It can be by making these things very clear in a WhatsApp information system, or it can be in the colleges. He can go and take some awareness classes, and it can be a sensitization program with the government agencies or with the police department for having some kind of an awareness in the locality or in the schools or in the public places whatsoever, to disseminate this information and sensitize the entire society about the right of women. So it is also always we can plan our ways and means to for dissemination and sensitizing the public at large or a particular group within which we are working.
Thank you, ma'am. The next question is from Vidya Ramkumar. Her question is why, after the submission of report, it's sent for second opinion when the findings and recommendations of the ICC/ICC is final?
It is not sent for second opinion at all. It is an appeal. See, sometimes the right of appeal is actually a right under the judicial system in every country, in every level, because the committee who are dealing with the matter without any intention, in a good faith, can commit a mistake. So if there is an appeal, the other level of people can sit and say, yes, this is upheld, this is correct, and we reiterate this report is final. So if there is anything has gone wrong, not implementing or not using the principles of natural justice, or this person has not given enough opportunity to defend himself. So these things can be identified in the appeal also. So it's a right of appeal is a right of every person in the judicial process. If we are not having appeal for death penalty cases, so several lives can be lost only because there is a very emotional pressure or that particular person has a perspective and all that. So it's a right in the judicial process itself.
Talking about appeal, ma'am, this is a question from Mr. Karthik. His question is, do we have to follow the same timeline if the respondent is going for an appeal after the recommendations?
Yes, 60 days is the time for 90 days is the time for him to appeal. 90 days.
The next
Within
question
90 days, he has to appeal.
Okay, ma'am.
He or she.
The next question is from Mahalakshmi. Her question is, women who do murder to protect them from sexual harassment will be punished by government?
Women who is working as a model, is it?
No, ma'am. Women who do murder to protect themselves from sexual harassment.
Yeah. See, yes. See, there is a provision for self-defense in criminal procedure code and in the criminal law system itself. So if that is a proportionate retaliation, see if he's coming for a rape or is trying to overpower and violate a person, definitely to protect her if she's in the melee, in the altercation, if he is dead, then definitely the law will come into a protection. See, it cannot be like a person is staring at you or trying to woo you by making some gestures. You cannot just take a knife and stab him. It has to be proportionate retaliation. If the offense that you are apprehending is very severe and it is costing your self-respect and life, then definitely a murder committed by the woman in defense of her person and life, she will be given a right of self-defense by murder.
Okay, ma'am. The next question is from Professor Jashwin John Bose. He's asking, women are covered under POSH. So what about men?
Yes, the men normally, see, every employer, every company, every government institution or a government body, department has a service rule provided for all the employees, one and the same. And so insubordination or obstructing a work to be done by a person or indiscipline or several other conduct are arraigned as a misconduct. So a woman committing an harassment to a man will definitely be a misconduct because it is affecting her work, it's affecting his mental peace and all that. So definitely by the service rule, as a indiscipline, as a misconduct, the person can give a complaint to the higher official or a disciplinary committee in the system, in their employment, in their office, and punishment can be given to her. Not under this act. There is no other specific act. See, there can be a specific act only for a class of people who are suffering a typical and a particular kind of problem. You can't say why POXO provision is not extended to the adults also. We are also citizens of India. So children are defined and seen as a special class of citizens who are having one particular way of violated upon against them and their children. And see, if we take the scheduled class people, and they already suffer lots of social, educational, and other backwardness due to caste system and other things. So we have a special law for them. Likewise, the women are also marginalized. They did not have their rights, entitlements for several decades, several centuries. And so there has to be a special law to bring them on par with the men and give them the right and protection for them to take part in the social production and involvement in the economic development, and to give them equality to live with the right to have work at the same time, right to work in a dignified manner and atmosphere. So it is a very special class of people who suffer a special and specific type of harassment, that is sexual harassment. We can't say in general men are all suffering from sexual harassment from women. Women are very demanding sexually. They are expecting all men to do their favors. They're showing pornography to men. This is not the fact. This is not the truth. And so there cannot be any special law for them. And when there is a special law that is also protected by the constitution under the clause of equality, the concept is equality among equals, not the equality among unequals. You will not consider a student of LKG and student of 10th standard for the same 100 meters dash to run together, because they are not equals. So equality among equals is the concept. So there cannot be a similar law or the same law that can be extended for men also, because in 1,000 cases there are about 995 cases or 999 cases or 900 cases are the harassment, sexual harassment by the men to the women. So this is a gender specific law, because the constitution provides for a special enactments, and also this is the pathetic reality of women being subjected to a special kind of a crime, which is a sexual harassment. Women has the right, they can approach through their misconduct in their service roles against women. The men can approach.
Okay, ma'am. Thank you, ma'am. These are the 3 last questions. And one of them is a repeated questions from many of the participants. They're asking you to elaborate the complaint process and the appeal process made under this act.
Okay. So as soon as a woman suffers or feels or being disturbed by a sexual harassment, she has to draft a complaint with the name, date, and details of the incident, and give it to the ICC or LCC, depending upon what kind of aggrieved woman is she. And so that has to go to them, and they will give notice to the respondent, answering respondent and the aggressor within 7 days, and then she has to involve. And one more thing which I failed to tell you is that there is a process of going for a conciliation. See, there can be an informal inquiry at the first stage, where if the woman is asking for a conciliatory process, then it can be allowed. The conciliation has 2 main and important aspects. One is that it has to be requested by the complainant women, aggrieved women. The second one is no conciliation proceeding can end in a monetary compensation. And if the woman says that he can be transferred to some other place, he need not come in front of me, I will go away to my hometown, so let this not be proceeded with. If the woman says that this need not go for an inquiry, or this need not be a formal inquiry conducted upon the sexual harassment, and there could be a conciliation to reprimand and to punish him in some level, or he is giving it in writing or a written apology to the women and to the committee, then it can be closed if it is asked by the women who suffered the injustice of sexual harassment from that person. So there can be a conciliation process. Soon after the complaint is given, respondent is asked to answer. So the in between stage is the conciliatory process. If the conciliation if conciliation is positive and he is abiding by the terms which is accepted in the conciliation finding or conclusion, then it will not go any further. It will be closed then. If the person who accepted on certain terms of conciliatory process, which cannot alone include any monetary compensation, all other things, he would not talk to her, he would not tease her, he would not talk to her colleagues in an indirect, implied manner, whatsoever it can be in that manner. If he is violating the terms, immediately the same complaint can be proceeded with a formal inquiry. Once the formal inquiry starts, the aggrieved women should give a list of witnesses and evidences that she is going to present before the committee. And the committee can call for other records independently from what is not been given by the aggrieved women and what is not given by the respondent in writing as an answer. So the committee can also connect it, and then committee will start the proceeding of an inquiry where the cross examination will be allowed for the women and the man in the presence of the committee, so that every proceeding will be recorded in writing and the signature of the aggrieved women and the respondent will be received. And after every process is over and after they exhaust all their points and defenses completed, then the committee will sit on deciding on the various aspects, the complaint and the witnesses and the other documents and the various aspects of forms of sexual harassment, and they will give finding. What is finding? To find whether there has been a sexual harassment has taken place as that has been given in the complaint or not. So after the finding, there will be a recommendation. Recommendation will be on the basis of the service rules and regulations of that particular institution. So there will be several things. One can be a transfer, one could be the cutting of increment or censure or entering something in their service record, or it can be compulsory retirement process, or it can be dismissal or termination. So the committee will recommend the punishment to be awarded to the person once they have a finding that the complaint has been proved, the complaint has been upheld, the sexual harassment has been proved, and they will give it to the employer. So all these things will be done within 100 days. That is, day 1, within day 7 to the respondent, within 90 days the conclusion of inquiry, and 10 days for preparing and finalizing the findings and giving recommendations and handing over the report to the employer in case of LCC to the district officer. So this is what is the entire complaint process and timelines.
Thank you, ma'am. We have the next question from Mr. Oliver. In an NGO setup where many visitors, interns, volunteers, guests, government officials do come and go for work, if any harassments are made by them or to them, in such situation, where should be the complaint be made?
In our office only. Wherever the other persons have come and committed harassment, in our office we can do. If the woman has gone to a secretariat, if the woman has gone to some school as a duty in the school from their office, if they are an NGO whatsoever, and she has to come back to her office and complain it to their ICC, who will also take up this matter to their ICC and call that persons. Sometimes it has happened even in my case. We have called 1 or 2 persons from the ICC to which the respondent aggressor belong to and have a discussion, and they will compel him or they will ask him, mandate him to attend the inquiry in the ICC of the employer company of the aggrieved women, and then the recommendation will be given to them also. Sometimes they also form part of the committee. The committee can have an extended membership. We can get the inputs from the employer of the aggressor also. So any woman, her company, her institution, her university is the committee to which she has to go at the first place.
Thank you, ma'am. This is the final question for the session. It's from Shubharana. The question is, under the EEOC guidelines, the law considers sexual harassment from superior, from another department, a co-worker, a client, or a customer. In India, however, it focuses on the employee being guilty. So why isn't a similar procedure applicable under the Sexual Harassment Act 2013 for better results?
I think you are talking about the vicarious liability of the employer.
Yes, ma'am.
Yes. So this we can desire, and long way to go. At least first, It is not the incidence of service. Why in India, I think there is no vicarious liability for sexual harassment. If there is anything else, if there is an embezzlement of public funds or any duty not done towards the public, then the higher official or the department itself is held liable. For example, if it's an health department and PPE, the protection gears have not gone to the hospital, definitely not the person who carries the PPE from one place to other place is held responsible. Definitely the secretary of health department or the commissioner of corporation is held responsible. But that is an incidence of official work for which they are doing the work. Sexual harassment is not incidence of their office work. It is from their mindset. It is from their mistake of that particular individual. So it is the individual is made responsible for the crime that he is committing. Only the setup is in semi-private, semi-public office space. If see, even the aggrieved women can also give a criminal complaint against the particular person in police station also, where he can be in prison for 3 years if the guilt is proved. So in such case, the employer cannot be held responsible for the criminal offense also. This is an individual committing a conscious or an unconscious act of sexual harassment to another individual. It is not an incidence of duty, so I think the vicarious liability doesn't come. But when it comes to a compensation, if so, the women is aggrieved and the committee has recommended that there shall be a compensation of monetary aspect after she suffered loss of employment or loss of any organs or loss of good mindset, or she has made into a vegetable state of life after this kind of a serious, severe, heinous crime of a sexual harassment. And then if there is a cash component is there, what you say is right. The employer should be made responsible. He should pay and then recover from the private person. So this is how it can be in a specific crime against one person to the other person. The employer cannot have a vicarious liability because it is not a definitely not an incidence of work.
Thank you, ma'am. Now I request you to give your feedback and your opinions on this session.
Thank you very much, and it was really very well organized. And at the beginning, I saw there was about 93 participants. Now I didn't see. Now it's about 90, and I'm very happy to have been with you for the past 1.5 hours. And the questions asked were extremely good and very pointed, and it is with a very good understanding. And I appreciate and I thank all the participants and also the people who have questioned, and it has really helped all other participants who have not questioned. On their behalf, I'm thanking you people who have questioned, and thank you so much for Madras School of Social Work and the Kritika and others who have coordinated with me very patiently. Thank you.
Thank you, ma'am. I now request Professor Jashwin John Bose to give the vote of thanks.
It is indeed a pleasure to deliver the vote of thanks. Ma'am, it was a very wonderful and an insightful session that we had today, wherein you took all the patients to start right from the history in terms of how the Constitution ensures such sort of rights and talking about the international conventions. And you spoke about the history of how this Act Quasha came into existence, especially the Banwari Devi case and things like that. And a prominent act, especially in India, wherein, as you rightly pointed out, after almost like 50 years, okay, the country is able to define what is sexual harassment of women, especially in a situation wherein, when you look at the 2019 statistics, it says nearly about 60% of the women are in the protective age group, of which 23.4% of the women are part of the labor workforce in India. So more and more, as you said, more and more of women are coming out today in order to help their families, in order to provide a better life for the children, a better education, better healthcare access, and things like that. And as they are coming out, we find that our women are forced to such sort of harassment and discrimination at workplaces. And I think this is one particular act which very clearly spells out in terms of the accountability part of it on the institution, the prioritization of in terms of prevention of such acts, and also in terms of providing innovative redressal mechanism for women who are harassed at workplaces and so on. So thank you for your wonderful session, ma'am. I hope all the participants will share the same thought with me. It was very clear and very simple to understand from your presentation. So, and I hope all the participants and as social workers, I think it is also our responsibility to take this message to everyone whom we come across, so that all our women and all our children who go to work, it is important that they should know this. They should know that this is their right, and they should stand up for their rights, and they should bring those perverts to justice. So, in terms of ensuring a safe and protective environment, not only for them, but also for the other women who are also working with them. Thank you very much, ma'am. And I also thank all the participants for your active participation, and request you all to fill the feedback form, which is posted in the chat box. It will be available for half an hour, so I request all of you to do it. And yeah, before 4 o'clock, you can fill it up. That is one thing. And we also request you to join us tomorrow for the session in terms of the Maternity Benefit Act, which will be handled by Professor Inian from MSSW. So thank you once again, ma'am. And
Thank you so much.
I wish you all a very wonderful day. Thank you.
Thank you.
Thank you so much, ma'am. Thank you, sir. General instructions for the participants. Please check the feedback forms in the chat boxes given in Zoom and in YouTube. The link will not be shared through WhatsApp or mail. The feedback form needs to be filled for the sake of your attendance and your evaluation on the session. Thank you, participants. Thank you.